CRJ 225. This is your podcast for section 2 of the course. I've asked you to do some reading. I provided you with some resources, and hopefully you've taken a look at those resources, especially the statutes, because what I'll say here will make a lot more sense if you have, and if you haven't, go back and do that. 720 ILCS Section 5, Article 6 of the code is titled Responsibility, and it refers to the focus of whether a defendant has the capacity to be responsible for his or her actions. And we know now that intent is an element that we have to have on the criminal side of the courthouse when we're pursuing criminal charges against someone, as opposed to, say, negligence on the civil side of the courthouse, where we just say somebody was being less than careful. And because we're looking at a alleged criminal defendant's intent, we are concerned with capacity, their ability to be responsible for their actions. We assume that they are capable, that they do have capacity, unless some of the things that were presented this week, especially through this part of the code, Article 6, infancy, intoxication, insanity. And then we'll talk about self-defense and use of force and all of that. Unless those things are evident, we determine that the person intended to commit the criminal act accused of, that element. It's a defense that the defendant can raise. It's raised by the defendant. The prosecution, the state, does not have to prove that the person had infancy intoxication. Infancy is less than 18 years old. Intoxication, or they had, a moment of insanity. That's something the defendant must raise. It's an affirmative defense that they raise, and then they have to prove it. So infancy, no person shall be convicted of any offense unless he has attained the age of 13. But we know, and you probably have been aware in other courses of circumstances where we do pursue adult status against a juvenile. But 13 is what the statute lists as the infancy cutoff. But we see these defenses debated more and more often as juveniles and very young kids commit heinous acts that were typically associated with adults. I'll link a case in my comments for this section, and you should go and read that case. Most of the time, infancy is a situation that's sorted out in the charging phase. As I said, that the prosecutor will decide, and we see more and more cases of a child and a juvenile being charged as an adult. That's always subject to challenge, and it's something that's very carefully considered. In most cases, we bring the child through the juvenile system. Now, Article 6, Part 3, titled Intoxicated or Drug Condition, it says a person who is intoxicated or in a drug condition is criminally responsible for conduct unless that condition was involuntarily produced and deprives him or of substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. Involuntary intoxications or drug conditions are rare, and remember, the defendant has to prove their defense, so think of some really good facts. It's difficult to prove that intoxication was not by their free will. Now, people can be tricked, they can be lied to, they can be drugged. And if they can show that they didn't choose to drink or take or use the substance, then they can use this defense. But note, negligence under that statute, failure to take proper care in doing something, is not a defense to criminal charge. So we'll get into the why of this in later weeks, but if somebody goes to the bar or is hanging out with people who are doing substances that they know could alter their state of mind, and they voluntarily partake in those drinks or substances, well, it's not a defense that you didn't have your right mind because you were intoxicated or drugged. You chose to do that. Your friend buying you a shot or giving you something and say, hey, take it, and you cave to the peer pressure, that's not a defense. Let's talk about the definition of a self-defense. Self-defense is the act of using force that, under different circumstances, would be unlawful. The only reason you use the force was to protect yourself or another person or property from imminent harm. The argument for allowing self-defense is what is known as an affirmative defense. You admit that you engaged in a certain behavior. Often it's you punched, struck, used force against somebody. For the purposes of self-defense, you have to prove that using the force was necessary to thwart an immediate threat or harm. If you remember our discussion of assault and battery, threat or harm. People have the right to defend themselves when they are attacked or they feel in danger. And this is what we determine to be self-defense. You have the right to defend yourself when you are either directly attacked or you feel in danger. Now, if you feel in danger, it better be pretty clear by the facts that you were, in fact, potentially going to feel some harm. Every state, including Illinois, has different laws that define what self-defense means. In Illinois, you can use reasonable force to defend yourself or someone else or to defend your home or other property. That statute is found at 720 ILCS 5/7-1. And the conditions that must exist to justify use of force, there has to be an imminent danger or threat to you, someone else, or your property. So the facts have to show that. The facts have to indicate, essentially, if you go back to what we discussed with an assault, that imminent danger or threat, the factors that cause someone to believe that a battery or property destruction is imminent, right? Or actual actions. That threat's got to be unlawful. Okay, that threat has to be unlawful. You had to believe that a danger existed that required force. And you must only use the force that is equal to the threat. So if a fist is raised against you, you can raise a fist. If it's some blunt object being swung at you, you can swing a blunt object back. If the person is unarmed, you're not able to pull out your gun and shoot them. You can't claim self-defense if you are the aggressor. You can only argue self-defense if you're reacting to another person's unlawful conduct and or trying to prevent a felony from being committed. You also can't overreact or act unreasonably in defending yourself. Now, the classic example that I've always given is you're in a situation, a place, public place, private home, wherever. Things get heated in an argument and someone strikes you. You can raise your fist to defend yourself and say, we've all seen these circumstances. Things get heated, two people get physical with one another. There's a point. There's a point when you're defending yourself, and there's a point when sometimes the other person stops whatever their behavior is, and the original victim then starts to pummel the person who struck them initially. That's when it potentially shifts from self-defense to you became the aggressor. If that initial aggressor ends up seriously harmed because you took it too far and you became the aggressor, you could in fact be charged with what? Battery? Likewise, somebody commits harm against you and that situation dissipates, people move on. Calmer heads prevail. You can't go out to the parking lot and wait for the person and say, hey, I owe you one. Now you're definitely the aggressor, right? Now, we should talk about proportionate and regular force. Proportionate force. What we mean by that is when acting in self-defense, you only have the right to use the level of force that's necessary to prevent harm. Not to lay a blow that's equal to the blow you took. Not to, if you got a bump that's starting to form above your right eye, it doesn't mean that you get to punch the other person until they also have a bump. It means you have the right to use the level of force necessary to prevent harm. The level of force you should use should be proportionate to the threat of harm you face. So using deadly force to defend yourself against a simple assault, for example, would not be proportionate. However, using deadly force to protect yourself or another person may be justified if you fear immediate and substantial bodily harm or death. And there's two levels of force: regular force, and then we'll talk about deadly force. Regular force, force that prevents someone from moving or acting normally. You're holding your ground, essentially. Deadly force is force that causes or is intended to cause bodily harm or death. You can use regular force to defend yourself or someone against an attack or entry into a home or any other type of property. For deadly force, we need to talk about three scenarios. First, deadly force as it applies to defense of a person. If you're defending yourself or someone else, you can use deadly force if you reasonably believe it's necessary to prevent imminent death or great bodily harm to yourself or another person, or you're in a circumstance that involves a forcible felony. Someone is trying to commit a forcible felony against you or someone else. Forcible felonies: sexual assault, battery, murder, robbery. Robbery is theft with a weapon, forcibly taking something from somebody else. Arson. All the forcible felonies are defined in um, Part 8, and they include murder, predatory criminal sexual assault of a child, criminal sexual assault. Now, we'll get to sexual assault at some point, but if you think, we call rape in Illinois sexual assault. So, predatory criminal sexual assault of a child, criminal sexual assault, robbery, burglary, kidnapping, arson, aggravated batteries, and any felony involving the use or threat of physical force or violence. As I think I've already promised in the first section of the course, we're going to get to some things like aggravating factors. And all of the crimes have some sort of aggravation and mitigation factors. Aggravated battery has different people or scenarios in which committing a battery against one of those persons or that scenario makes it aggravated. I'm older than 60. You don't like your grade and you come up and punch me in the parking lot, you committed aggravated battery. That's a felony. You can go to the joint for that. We'll get into those aggravated factors later. And please don't ever do that to me. Defense of a home. You can use deadly force to prevent an assault or threat of violence against yourself or someone else in a home or other building, but only if you use it against someone who is trying to enter in a violent manner, or you reasonably believe that such force is necessary to prevent a forcible felony in that building. So that's the home. And our home is where you lay your head to sleep, okay? I've been involved in various types of cases over the years where people try to play games about, um, where their home was. Crazy stuff, criminal stuff, administrative stuff. I was um, on the Fire and Police Commission for a good chunk of years, and that's the body that hires, promotes, disciplines fire and police personnel. I did it for the city of Peoria. The city had a requirement that if you worked for the city and you reached a certain level of management, you needed to live in the city. And personally, I think that if you're going to teach, serve the public in any way, all the things, that you should live where you get your paycheck. But um, this was a requirement, and there was an individual who was renting a place and then got outed by somebody who didn't like him, knew what he was doing, and he tried to say, well, that's where he slept a night or two a week. No, it's your home is where you live. we all know where our home is. It's where we go every night, or most nights, hopefully, and we sleep and we have our clothes and we interact with other people most likely, and we have our meals or keep our food and yada, yada, yada. That's the home. There is uh, an issue that comes up all this time about defense of property. And deadly force is generally not allowed to be used when you are protecting your own personal property or real property. So, what I mean by personal property is anything that's not real estate. And real property would refer to real estate, but it's real property is real estate that's not your home. So, somebody walks into your fenced backyard, unless they are headed towards, or it looks like they're going to try to come into your home, you can't use deadly force. If they're breaking into your car, you can't use deadly force. Unless you reasonably believe that such force is necessary to prevent one of those forcible felonies that we discussed earlier. Let's talk about stand your ground, because people always bring that up when we're talking about self-defense. And in Illinois, you do not have a duty to retreat before using force to defend yourself from danger. While there's no explicit language in the state's criminal code, state courts have expressed that there's no requirement to escape danger before resorting to force. However, Illinois uses a similar doctrine to stand your ground called the Castle Doctrine. Both stand your ground and the Castle Doctrine jurisdictions differ from duty to retreat states because they don't require an individual to first retreat from the danger before using force against an attacker. However, the Castle Doctrine gives people the right to avoid retreating into their homes in order to protect themselves from intruders. The intent of the law is that your home is the equivalent to your castle. Being the queen or king of your castle, you should not be required to retreat from people who have no right to be in your home. So you have to leave your home. It limits this right to the home as contrasted to stand your ground laws, which have no such limitation. You may have seen some of those cases. Typically, they seem to come from Florida. There's been some, you know, avoidable deaths by people who claim stand your ground and shot someone, usually an unarmed someone, and that's not the law we have in Illinois. So you move to one of those stand your ground states, know what that law is. But for here, it limits the right to the home. And to be clear, it's available in your home. All of these defenses have the same time and distance expectations that essentially expect you to you defend and not become the pursuer, the aggressor, as I talked about earlier. Don't become the primary perpetrator of an offense. And remember that over time and distance, someone who may be defending themselves and using force to defend themselves legally may in fact become the perpetrator of another crime. So if a person enters your home, you can defend yourself and your property. If you chase the individual out of the house and onto a public sidewalk where you hit the individual in the head and they die, you won't be able to use this defense. So actually, you had to be involved in a case just like that, where the individual was defending their home and probably doing just fine until they became the pursuer, the aggressor, and chased the individual out of the house and halfway down the block and struck the person in the head with an aluminum baseball bat. Not once, but more than once. And you know what happened from there. So time and distance is something we're going to explore in a lot of different contexts, but especially when we're talking about any of these defenses, time and distance always seems to come up. So time and distance from the initial action, say, here, and then what happens afterwards. This is probably a good time to recognize that we urge, or I especially urge you to provide a good recitation of the facts of any case I ask you to discuss. The facts tell the story. The facts identify the elements of any crime or defense, whether those elements exist or not. The facts tell us about time and distance. Since it's become, you know, too common, especially in recent weeks, and I try to record these. I teach this class 3 times a year, and so I record usually, unless the law changes, I make a recording for the whole calendar year that I reuse, and then I supplement in my post, or if it needs to be redone to add some substantial change in the law, I'll do that. But the things that I've witnessed in the last few weeks here in 2026, they require a little bit of coverage. So let's talk about use of force by the police, just so you're informed. And if you intend to go into law enforcement, and even if you're a criminal justice student, you should take my summer course, CRJ 227. Law enforcement students are required to take that course, but any student, and especially criminal justice students who think they might want to go in law enforcement, would be well served to take that course, because that course covers what you will need to know to avoid being sued or perhaps arrested and prosecuted as a police officer if you do things that are contrary to the law, contrary to the procedure for interacting with the public from the time you first encounter a person until you take them into custody and thereafter. It's essentially the same basic criminal procedure course that I offer to police officers through the Central Illinois Police Training Center that's located at the far end of Poplar Hall, the Peoria campus of Illinois Central College. It's to your benefit to learn those things before you get hired, before you go to the academy and you hit the streets as a police officer. The academy does a great job. Your FTOs and your departments will do a great job of trying to get you to understand these things. But if you can learn these things this summer, you should do it. And like I said, it's required for law enforcement. And if you're CRJ intending to transfer and intending to get into law enforcement at some point in your life, it won't hurt you to have this knowledge, especially today. I get into the details far greater in that course, and um, I think you should understand that this is basically a summary that hopefully helps you understand whether what you're seeing, right or wrong, um, what it is, and at least something that you should really pay attention to, and perhaps, I would suggest getting the mindset of avoiding for yourself. That CRJ 227 course deals with the basic expectations of the procedural side of law and how it sets parameters for the rights of the people we interact to or with in law enforcement from the initial contact all the way through arrest. It introduces things like interviews and interrogations, confessions, and procedural expectations for the lawyers, the courts, the justice system after the law enforcement officers have done their job. And for many years, use of force wasn't a topic we saw covered traditionally as a criminal procedure topic in textbooks or training courses. It still isn't widely covered as a procedural topic in those textbooks. but I can tell you that it damn well should be. And so I added it to my 227 course a while back. There hasn't been a lot of case law guidance over the years like is for arrest, as an example, or what it means to be in custody, or stop and search, and all those things. It's typically because there's a clear set of expectations for all those things. All the expectations that came from landmark Supreme Court cases and have been adopted by police departments as policies, taught in extensive police training, and defined in statutes. But as you know, the attention brought to the use of force by police officers and then some federal agencies in recent times, especially this past year, have created a lot of additional scrutiny. They made the job a lot harder. The murder of teenage Laquan McDonald in Chicago in 2014, Eric Garner in New York City, Sonia Massey more recently in Springfield, Illinois, George Floyd, Renee Good, Alex Preddy in Minneapolis, and far too many others. Deaths that were, in my opinion, avoidable if we did our jobs to train, supervise, and make better decisions about who we hired and retained for law enforcement jobs. Now, in Illinois and several other states, we have defined statutory expectations for police use of force. We define what force is and when and how it's appropriate under the law. I added this topic way before we had the statute for two reasons. First, I don't want to wake up and read about one of my former students being involved in the misuse of force, alleged or actual, and especially the misuse of deadly force. I don't want it for them. I don't want it for my community. I don't want it for the person who was harmed or worse, killed by a police officer failing to follow the law. And second, it's not complicated. If we teach, train, and expect police to have basic knowledge of many of the practices and principles we offer in that 227 course. The basic expectations that I believe our Illinois local and state departments teach and train our police officers to recognize, and we should expect our law enforcement to work by each and every day. And I should probably throw in here that we've had many Illinois Central College graduates go on to work for federal agencies who received extensive training, 52-week academies, all sorts of procedural training, all sorts of probably some of the better training you could expect anywhere in the world, who didn't do these things. I've studied, followed, and served the law for well over 40 years. These were expectations I was taught, trained on, and expected to work by. I don't see it as being complicated, and you shouldn't either. It's fairly straightforward. If you take all of what the law expects from the first encounter with a police officer, if you take all the law expects from that encounter through arrest and everything related, and you consider and follow what the law expects at each of those junctures, the expectations for use of force in those interactions are spelled out for you in the same context as those other expectations. Reasonableness of the action under the circumstances. Just reasonable actions under those circumstances. Whether you should have used force and to what degree the force was warranted doesn't fall under a different standard. What the law expects of law enforcement in this area is not more complicated than what it expects of law enforcement in any other setting when interacting with the public. Reasonable actions under the circumstances. Now, the difference is that when use of force becomes a question and circumstances have shifted to a concern over the safety of someone else, a bystander, a victim, yourself, or a suspect, the law enforcement officers, it's generally when the officer wasn't properly trained or doesn't operate by his or her training or department policies. It's when they get sped up, they fail to take a deep breath, they don't fully process the situation, they aren't supervised properly. It's then when we see issues come up and horrible tragedies occur. Before we had statutes to define the use of force by police, the most common definition of what use of force is and what we should look for, it was a definition developed by the International Association of Chiefs of Police. It defined police use of force as the amount of effort required by police to compel compliance by an unwilling subject. Amount of force required by police to compel compliance by an unwilling subject. The Illinois statute found at 720 ILCS 5/7-5 states that an officer is justified in the use of force which he reasonably believes, based on the totality of circumstances, to be necessary to effect the arrest, and of any force which he reasonably believes, based on the totality of circumstances, to be necessary to defend himself or another from bodily harm while making the arrest. Legislatures often add more words than I sometimes think need to be put into their statutes, but essentially what they're saying is the reasonableness of the action under the circumstances. The statute says is excessive force would refer to instances where an officer uses more force than is reasonably believed to be necessary in that circumstance. Now, as I said, there's not a lot of specific use of force guidance from the United States Supreme Court. And when you take CRJ 230 and CRJ 227, we get into a lot of landmark Supreme Court cases that defined essentially what police procedure and procedures of evidence, etc., on the criminal side of the courthouse expect. But you might ask, why aren't there a lot of use of force cases or guidance from the United States Supreme Court in use of force? Because sure the heck seems like we have plenty of examples where police have used force improperly to the great bodily harm or death of someone. And that would be a true statement. So why don't we have a lot of guidance? Well, I think it's because to get to the question or issue about whether use of force was reasonable, there has to have been some interaction between the individual and police officer. And when things go sideways enough to create a use of force issue, more often than not, there's some circumstance or occurrence that wasn't quite right in one of those other procedural areas, from which there's a lot of guidance provided by the courts. For instance, there's a lot of cases and clear guidance on the expectations of stopping someone, of detaining someone, of arresting someone. If the use of force arises because there was a concern or violation of expectations in one of those areas, it makes the concern over the use of force or excessive use of force fairly clear. And you can take any one of those examples that I've offered, those real life cases, those real life deaths. And if you break down the circumstances, and in some of those we have court cases to go by, we have convictions of the officers involved. When you break those cases down, you look at the totality of circumstances. One or more of those interactions went awry. Procedures weren't followed. Training wasn't given or followed. Too many people were involved. There wasn't a quality and present supervisor. Oftentimes, in those circumstances, other police officers and the public were put at danger because of what the reaction or improper actions in detaining or stopping or whatever were used. The bottom line, though, is this: follow the law. Learn the law, take the 227 course, pay attention when you're hired and you go to the academy. Follow, learn, know, follow, train on your department's procedures. In my course for police officers, I stress, most of the time when we interact with somebody, if you're trying to arrest someone, there are physical movements. Practice those physical movements. Practice those physical movements so you can safely put handcuffs on someone. Safely for them and safely for you. The bottom line is this: use of force or use of deadly force by police can result in criminal charges against the individual who misuses force or deadly force. Can also lead to criminal charges for others who are employed as law enforcement who stand by and watch another police officer's improper or excessive use of force. And it will lead to civil suits against all of those people, their supervisors, their departments, the governmental entities that are responsible for those departments. In all the cases I listed and all the circumstances we could discuss ad nauseum, there is most likely a civil suit that has been filed and settled. Those cases typically do not go to trial because the standard of proof in a civil case is different. Gathering evidence is different. The civil process, the discovery process, is more in depth with different expectations. And somebody's paid some money. And just so you know, my position on all that, I worked both sides of those, criminal and civil, and worked civil cases where money was the goal. Money damages never bring back the person who's deceased. Money damages never make the person who's been subjected to great bodily harm whole. Ultimately, the thing to keep in mind for people who are intending to go into law enforcement is that you take an oath to enforce the law and you need to work by and within the law. And that's really for anybody who thinks they want to serve in the law, whether it's through the legal studies program, 911, or you want to be a probation officer, work in corrections, what have you. You're going to make those choices. You're going to head down that path. Then use your seatbelt. Stop speeding. Don't do things you know are contrary to the law. And again, it should be fairly simple and straightforward. You can't expect to use force that an average person couldn't use under similar circumstances and get away with bodily harm or murder. So be aware of that fact. And if you want more on those topics, and you want to avoid those circumstances, have a long, prosperous career, sign up for the 227 course this summer. It's offered online. It is some work, but most people who complete that course find it to be one of the more enjoyable courses they complete. Definitely one of the more beneficial courses towards their careers, whether you're in any of those programs, and seats are filling up, so see your advisor soon. All right, that's my podcast for section 2. If you need me, you know where to find me.